morning. This is Amanda.
Hi, Amanda. My name is Joe Thomas, and I have my client Brian Green on the phone with me. And I believe that I received a call from you earlier, and I'm just returning that call.
Yes, I did make a phone call to you earlier. I did receive that you filed a notice of withdrawal of counsel for the Brian Green versus the State of Washington, the 53728-1.
Okay.
Filed that yesterday. You don't have any of Mr. Green's information included in that, and obviously if you're withdrawing from being his attorney, that's who we are going to have responsible for filing that appellant's brief on the 26th. And so I don't have any information in regards to telephone number, address, email. Obviously you didn't mention anything about a new attorney representing him, so then we're just going to put him on pro se and go from there. But like I said, I didn't see that included in that notice, and I was just going to let you know that you probably need to file an amended, or I was just going to send out a letter, honestly, just so that the other party's aware that we don't, if we don't have his information, we don't know who we're supposed to be putting on if I don't have a way of contacting him,
Okay, no problem. I will just file a notice of, or an amended notice of withdrawal later this morning then, and I'll include Mr. Green's contact information.
Perfect, and then that way we could get you off and we could get him on, hopefully he is aware that the brief is due on the 26th, and so.
Yes, he's on the phone with me. Okay. So I have a quick question about that. How is the brief due on the 26th when the letter says the appeal hasn't been perfected?
I'm not exactly sure. Let me go into the file.
It's just a quirky procedural thing for me, just from my own understanding. As we talked about before, I'm a relatively new lawyer, and I thought that the perfection of an appeal, once the appeal is perfected, then the court sets the briefing deadlines.
It was perfected back on the perfection schedule went out July 12th.
But the first sentence in the letter says, "Our records indicate that you have failed to timely perfect the above referenced appeal." And it's signed by your boss, Clerk Byrne.
That's just the language in the letter. It's not necessarily perfected as in like the perfection schedule. It just meaning that you haven't got your brief in, because you're talking about the language in the sanction letter, correct?
Yes.
Yeah. It's not necessarily referencing that the appeal itself isn't perfected. We've established that this appeal has been perfected. We've got record in, and so that sanction letter is just mentioning in regards to perfecting in regards to the briefing schedule.
Okay, because it's still asking for the clerk's papers in there too, like for an amended clerk's papers, and that's why it's saying that.
Well, yeah, and the clerk's papers were included in that because, you designated clerk's papers, but obviously, if we have to have the clerk's papers sent to us, so that either means that you haven't paid for them at the county, or something, or you have paid for them at the county, or you just need to contact the county to see what that delay is, because we have not had the clerk's papers sent to us here at our court, and that obviously if there's no record to review, there's nothing for you guys to cite to in your brief. There's I'm just, it's not going to work too well without any documents to be reviewed. Do you understand what I'm saying?
Yeah, and so then I have a second question. So it talks about that there's a motion scheduled, and so just so I can relay this to Mr. Green, has a motion been filed for a dismissal?
No, because that letter gives an additional time frame for those documents to get in. So there has not been a scheduled motion, no.
But it says that a commissioner will hear the motion on December 26th if the brief isn't filed. And so then how's Mr. Green going to know about the motion then, so I can explain that to him? Like, how is he going to have timely notice of a motion in order to respond to a motion?
Well, it's not like necessarily like a drafted up motion that the commissioner does. It's just here's this motion. The court puts this matter on for either further sanctions or dismissal, because this is a civil matter. So, sometimes further sanctions, it really doesn't matter about further sanctions, because, some appellants will decide that in a civil matter that they don't want to go forward, and so we can't obviously hold them to pay further sanctions, or we'll just dismiss the case. And so it's just a court's motion for either further sanctions or dismissal, and so it's just that it's not necessarily a document. It's just that's the date that, oh, okay, we noticed he still hasn't got this filed. Okay, what's going to be the next step?
Would Clerk Byrne file the motion, or would the court actually would Commissioner Schmidt or another commissioner file the motion then?
But it's not an actual filed motion, is what I'm saying to you. So, but it will be either the clerk or the commissioner. It's either or.
So how would he? So if it's not a filed motion, so I can explain this to him, how would he have a chance to respond to it then?
I mean, he could file his brief. Would be, I mean, a great thing, but I mean.
And how would the public have a chance in order to see this then, if it's not a filed motion? So the commissioner is going to be making a decision on something that's not filed in the case.
It's not necessarily like that the public needs to see it. I don't, you get into a lot of extra questions, and I'm not exactly sure if I know the correct answers for you, Mr. Thomas, and I don't want to lead you down the wrong path. So,
okay, well, if you can let me know so I can.
You feel free to look into the RAP rules. That's definitely the place that you want to go in regards to some of these questions. Some of these questions that you're asking, I'm not an attorney, and I can't give out legal advice, and I don't know you ask a lot of extra procedural questions that maybe I'm unclear about, and so if you would like some clarification as to some of these answers, it might be better for someone else besides me to answer them for you.
Well, if you could get somebody else to call me, I would appreciate it, because your email sent this letter to me, and your boss.
I'm the case manager. Of course, my email is going to be the one that you sent out.
Okay, but your boss signed the letter, Clerk Byrne. And so I would imagine either you or Mr. Byrne would be able to answer these questions. I mean, I'm not calling you up with random questions.
Yeah, I didn't say that you're calling me up with random questions, but it's just the questions that I haven't been asked before, and I'm unsure of the answer. So I can definitely get you a call back, okay?
Oh, would Clerk Byrne call me back, do you think?
I don't know who's going to actually give you a call back. I can definitely ask around to some of the senior case manager, and definitely talk with the clerk and see who it would be that would give you a call back. I'm not sure who that would be right now.
Okay. Well, thank you so much. I appreciate it.
Yep. You have a wonderful day.
You too. Bye.
I can provide legal information, but nothing further in that regard. But I understand that you had some questions regarding Mr. Green's case.
Yeah, so I received a letter on December 11th with your signature on it, and there was a couple of confusing things. Oh, would you like the case number for the letter?
Is that 537281?
Yes, sir.
Okay, let me just open up if you'll give me one moment, I will make sure I have all the documents in front of me. Thank you, sir. Okay, so I'm looking at the letter in question.
Okay, so the first thing is, literally the very first sentence of the letter says the records indicate that to timely perfect the above referenced appeal by not filing the appellate brief, but I thought that the perfection dealt with just getting the necessary preliminary documents in, like the clerk's papers, the notice of appeal. And so I'm a little confused on what to tell Mr. Green about that.
Let's see, taking a look at the dates here. Okay, so based on this letter, my understanding is that Mr. Green has until the 26th of December to file the clerk's papers with the court and the appellant. I can provide legal information, but nothing further in that regard. But I understand that you had some questions regarding Mr. Green's case.
Yeah, so I received a letter on December 11th with your signature on it, and there was a couple of confusing things. Oh, would you like the case number for the letter?
Is that 537281?
Yes, sir.
Okay, let me just open up if you'll give me one moment, I will make sure I have all the documents in front of me. Thank you, sir. Okay, so I'm looking at the letter in question.
Okay, so the first thing is literally the very first sentence of the letter says the records indicate that to timely perfect the above referenced appeal by not filing the appellate brief, but I thought that the perfection dealt with just getting the necessary preliminary documents in, like the clerk's papers, the notice of appeal. And so I'm a little confused on what to tell Mr. Green about that.
Let's see, taking a look at the dates here. Okay, so based on this letter, my understanding is that Mr. Green has until the 26th of December to file the clerk's papers with the court and the appellant's brief to the court.
But the clerk's papers were already filed.
They may have been. We don't have the clerk's papers presently.
Okay. Well, Mr. Green can't file the clerk's papers. He can file a designation of the clerk's papers, which is what he did.
Correct. But we have not received the clerk's papers from the county. So either they haven't been paid for, or the county needs to be contacted by Mr. Green to assure they're received by the court.
So you're threatening to sanction Mr. Green for something that's in the power of the Thurston County Clerk's office. Is that correct?
That is correct, yes. That's why we send these letters out, so that we are notifying people before any sanctions are filed against them, so that they can rectify the issue.
Okay, well that's okay. So then I still don't understand why the first sentence says that Mr. Green hasn't timely perfected the appeal.
Well, because the initial appellant brief was due on 12/9, and so that was the due date. We did not receive either an extension request or an appellant's brief, which is why the letter was issued.
So, but does the perfection have to do with the filing of the opening brief?
So when we say timely perfect, that just means that based upon the initial perfection letter, the original appellant brief was due December 9th.
So if you don't have the designation of the clerk's papers, how can you say when the opening brief is due?
We do have the designation of clerk's papers. We don't have the clerk's papers.
But Mr. Green can't provide the clerk's papers, nor could I. Like, that's not within our power, as much as we'd like to.
That is correct. But if we don't have them, then it's the responsibility of counsel or the pro se appellant to contact the county to make sure that those clerk's papers are submitted to the court.
So how does Mr. Green force the county in order to turn those over then? To avoid the sanctions, like how does he force them? Because he doesn't, my understanding is he doesn't have the power to do anything if they don't want to. Like, how does he force them to turn them over and to avoid the sanctions? Because it seems like you're sanctioning Brian Green for something that somebody else is doing, which doesn't seem fair.
I'm just giving you the information that you need to communicate with the county, a reminder, so that because it's not the county that's responsible for making sure that the clerk's papers get here. the appellant and their counsel. And so we're just giving you notice so that you can work with the county to get them there. If there's a problem with the county not being able to submit the clerk's papers by the 26th, we invite any and all appellants or patrons of the court to communicate with our office, and we will work with them.
Okay.
Our interest, we get nothing. We don't receive any revenue by sanctioning. Those funds go to the state. We don't care to collect. What we care is to move the case forward for all parties.
Okay, so then it says that there's a motion scheduled for dismissal and or further sanctions. So I didn't receive a copy of that motion.
Well,
and
that motion
passed along to Mr. Green.
This is the letter is notifying Mr. Green. Well, in this case, I believe you may have still been counsel at the time, so the letter was sent to you to let you know that we would then review the case when it comes up on the motion calendar, which is my calendar of things that have passed on a due date, and then we review them. There isn't a formal motion. This letter serves as that motion.
So how will we? So there isn't, but it says there's not a formal, like what court procedures allow you to file a not a formal motion? Like I'm confused about this. And how does the public get to know about this not formal motion? And Mr. Green, like how does he respond to a not formal motion?
The letter gives him all the information that he needs to move forward.
But can you tell me the court procedures? Because I don't see any legal authority in this letter that would be in a formal motion.
So the authority that we use is our authority rests on RAP Rule 7.3, and then is with regard to sanctions, RAP Rule 18.9.
But Mr. Byrne, like surely you can appreciate that if it's not in that paper, like then there's no legal authority for the court to act on. And you're saying that there's not a formal motion. How is Mr. Green or even the public supposed to know what the basis for the sanctions, like what the legal basis for the sanctions are?
The letter makes that clear. The legal basis for the sanctions is that the appellant has not filed their brief and clerk's papers to the court at the date that they were supposed to.
With all due respect, Mr. Byrne, the letter doesn't state any legal basis. It doesn't state any statute or any court rule or even any common law that gives you the basis to do this.
I just gave that to you. That is RAP 18.9.
But Mr. Byrne, that's not in the letter. That's what I'm saying. In a formal motion, you would state and I'm sure that you can appreciate this because you see these everyday motions, and you state the legal authority. The court's not a mind reader, so they can't know this, and the public's not a mind reader when they see this document, nor is Mr. Green a mind reader. And so I've never heard of a procedure for a not formal motion before, so I'm trying to be able to explain this to Mr. Green. And surely, like, you must know of a procedure if you're stating that there's some sort of not formal motion, and I just like to be able to know, like, what to reference.
So each appellate court has a procedure that they use. So when a appellant fails to file, then we utilize 18.9 sanction rule to notify all parties to the case that this is what the sanctions letter is going out to help them to understand what's going on in the case next.
Okay, so this letter, you're telling me that this letter acts as the motion?
Yes.
Okay, so I'll just explain to Mr. Green that there's no law or authority in this letter because there's nothing in this letter. I mean, you're explaining to me other things that aren't in the letter, but there's nothing in the letter. And so, will you be the one seeking sanctions against Mr. Green?
Would I be the one seeking sanctions against Mr. Green?
Well, somebody has to be the moving party. So I'm wondering who the moving party is.
The court.
Well, the court, I mean, the court can do it sua sponte. So if the court is going to do it, Commissioner a commissioner can do it or a judge can do it, then you wouldn't be doing it. You wouldn't be writing me the letter, or Mr. Green the letter. So, is the commissioner doing the sua sponte, or is your office moving for this? Because you wrote the letter, and you didn't reference that the court was doing this. Your name is on it.
That is correct, yes.
So, are you the moving party then?
Yes.
Okay.
The court is the moving party.
Then do you have a lawyer representing you in this matter when you're seeking sanctions? Because you're filing a motion with the court, even if it's not a formal motion. You're asking the court to do something. Do you have some sort of lawyer representing you that Mr. Green should address? Because it seems like this is a practice of law.
This is not a practice of law. I'm just applying Rule 18.9 and moving forward on the case.
So you're applying the court rules by yourself to Mr. Green, right?
Not by myself, no. This is part of our procedure that we use on every case when someone does not follow through with their responsibilities on a case.
Right, but I'm looking at the letter right now, and it's your name on the letter. I don't see on behalf of the court or anything else that would lead me to believe that it's for anybody else. It's just your name on there. Very truly yours, Derek Byrne, court clerk, with your signature.
Everything that I do is on behalf of the court. You're well aware.
Okay, but I thought only lawyers, like you're not a party, and I thought only lawyers could file motions with the court. Am I wrong?
Well, see, there we go back to 7.3, about 7.3, which allows the courts to manage each of their cases.
But there are statutes that define the unlawful practice of law, and the court rule can't supersede statute on substantive law, maybe on procedure, but not on substantive law. And the substantive law is what defines the unlawful practice of law.
Again, we come to the point where we agree to disagree.
Okay, so there's no legal authority in this letter, and it's being brought by you, is that correct?
It's being brought by the court, yes.
Okay, well, thank you very much for your time. I appreciate it.
Goodbye.
Okay, bye.